Welcome to the Red Wagon Estate Planning and Elder Law Show, hosted by me, yours truly, Jeffrey Belomo, where we discuss all things estate planning and elder law, and, well, hey, anything else we want to talk about. Now, today we are going to talk squarely about estate planning and elder law. Our topic today is going to be what not to get your kids for the holidays. And we will also discuss then what to get them, but the most important question is to what not to get them for the holidays. Now, before we begin, as on every show, I'd like to just remind everybody that you should not look for legal advice on this show or any other radio show for that matter to constitute legal advice. If you're looking for legal advice in regards to a certain situation, please contact an attorney licensed in the state that you are in that practices specifically in the area that you are looking for advice in. And then, and only then, should you take the advice that you are given to constitute legal advice. This radio show is for information and entertainment purposes only and for educational purposes. If you're looking for legal advice in regards to a specific situation, specifically in regards to estate planning and elder law, we would love to help you at Belomo & Associates. To that end, we offer free educational workshops in estate planning, crisis planning, special needs planning, as well as administration, both probate and trust administration after the death of a loved one. You can get information about our free educational workshops on our website at www.belomoassociates.com or 717-845-5390. We would love to assist you. All right, back to the show. So what should you not get your family or kids for the holiday? Well, to me, your number one thing that you should not be doing them is writing them a check or giving them cash or giving them money or putting their names on your assets. Now, some of you will have a hard time hearing that. Just hear me out for a second. You have to be very careful in understanding all the rules before you start gifting things. And unfortunately, too many people only know the tax rules. So the tax rules say that you are allowed to give up to the annual exclusion amount that is applicable in the year in which you are looking to give money away. Now, currently, we are in the year 2023. We're coming up on the end of it, heading into 2024. As we sit here today, you can gift $17,000 a year away to anyone that you want for any reason, for any purpose. So what many parents will do is to give the $17,000 to the child, $17,000 to the child's spouse, $17,000 to the other child, $17,000 to the other child's spouse. And they go through that. And of course, in their minds, they're doing it because they're allowed to do it from a tax perspective. And yes, that is technically true. From a tax perspective, you are allowed to do it. In fact, I'll do you one better. Not only are you allowed to do it from a tax perspective, but in addition to that annual exclusion amount, you're also able to give away an additional $12.92 million a person. So a husband and wife can give away 12.92 plus 12.92. For the sake of math, let's just call it 26 million. And it's important to point out that as we are headed into 2024, my guess is that the annual exclusion gift will go up to 18. And my guess is that with inflation, the federal exemption amount will be pretty much at 13 million a person. Those are not guarantees. To my knowledge, the final numbers have not been posted yet as of the date of this recording. But either way, that is a lot of money that can be given away. Let's be honest. For most people, they do not have more than 12.92 million. And if they're married, they don't have more than 26 million. So the truth is you can give away pretty much everything you own tomorrow. But here is the rub. Here is where things get interesting. Just because you're allowed to do it from a tax perspective doesn't mean that you should, because you're giving up control. Doesn't mean you should, because you could be causing your kids a horrible tax consequence later in regards to capital gains tax. And if you end up needing long-term care, it doesn't mean you should, because there is a 5-year look-back period for any transfers that you're giving away and looking for the government to assist you for your long-term care costs, right? The average cost for a long-term care situation in the state of Pennsylvania is $14,676 a month, right? So you have to be extremely careful when you make a decision about giving money away solely because of the tax implication. The truth is, you could give away every penny tomorrow without a tax implication, but let's talk about it a little deeper. All right, so let's say that my dad puts my name on his assets, on everything, okay? All right, who owns the assets? I do. All right, now I own them, so they're subject to whose divorce? Mine. Whose car accident? Mine. Whose long-term care situation because I had a stroke? Mine. And let's not forget, if my dad puts my name on everything and I pass away, who is probably going to get everything I own? My wife, right? Okay, so now I've passed away. My wife gets everything. What are the chances that she is going to allow her ex-father-in-law to live in her house for free? Oh, I'm going to say there's a good chance, right? I trust my wife implicitly. I believe unequivocally she would do that. All right, well, let me change the facts. She remarries. 10 years later, what's the chances that Butch, her new husband, will allow the ex-father-in-law to live in the house that they own together jointly for free? I don't know, right? I don't know the answer. And the truth is, by my dad putting my name on it, he is now subjecting it to my long-term care, to my divorce, to my stupidity, to my car accidents. He has worked way too hard to be taking a chance on stuff that could affect his ability to live in the house, his ability to access the money, right? If I'm in a nursing home and I own the asset, they're subject to that's an asset for me, but it's still an asset to him because he gave it away within the 5-year look-back period. Let's say the house that he owns, he paid $20,000 for. If he puts it in my name and I own it, my basis is now the carryover basis, which is also the basis that he has at the time that he transfers it. So if I get it gifted to me, my basis is now $20,000. If I sell that house for $200,000, what is 200 minus 20? $180,000. Subject to capital gains tax at up to 23.8%. Guys, my father would have been way better off putting it into a trust that he controls or continuing to own it in his name alone until the time of his death. In either instance, if he controls it in a trust or it's in his name and he passes, I then pay 4.5% through the estate. His estate pays that 4.5% tax, but now my basis is 200. So what is 200 minus 200? 0. That is what is subject to capital gains tax. 0. Would you rather pay 4.5 on 200 or 23.8 on 180? You know the answer, but it's so tempting to want to gift assets and stuff to your kids. You want to be very careful because not only are you giving up control and it's subject to the kids' creditors, but you're also subjecting your family, your children, to a huge capital gains tax. The inheritance tax is way less than the capital gains tax. As far as what you're allowed to gift per month, if you end up having a long-term care situation, less than $500 in a month. All right, so yes, that's in total. Yes, that's in aggregate. Yes, that's in sum. Yes, that's all of the gifts together. So what that means is you can give less than $500 a month away or gift it to whomever you want without an issue. But that's collective. That's total. That means you can only give a total amount of less than $500. Not 500, 500, 500, less than 500 in total. So we always recommend starting with a 4, like 499 or 495 or 490. That way you're staying away from the $500 number because counties interpret that number differently. So we always want to keep it less than. All right. So that means that if you want to give gifts away for Christmas, what is the best way to do it? The best way to do it is to do it throughout the entire year where you're taking money out at $495 a month every month, and then you're collecting it, and then come December, you now will have a little less than $6,000 that you can give away. What if you wait until December? So this goes back to what should I not give the kids at the holidays? Don't write them a check. Don't do it all at once. Because if you do it all at once and it exceeds $499 or it starts with a 5, if it's over $500, that will cause a penalty if you end up in a long-term care situation. Now, it may be too late for this year. If you're not in a position where you are 100% confident that you're going to get outside of 5 years and not need long-term care, you probably shouldn't be gifting money away. Now, next year, you can start with $490 and go ahead and get a collection together, and then that way in December, you'll have the ability to give money away to your kids. But if you do it this year, that can cause you a major problem if you end up needing long-term care. And remember, the long-term care situation have a right to sue. The nursing homes have a right to sue under the filial responsibility statute, which says that children are responsible for the nursing home debt of the parent. And it says all children are equally responsible, meaning if you give money to your grandkids or you give money to one child, but another child is the one that has money, they're going after the child with money, right? They're not going after the child who doesn't have any money. So you may have gifted money to a child who needed it, but you are now subjecting your other children to a problem if you can't afford it, because the nursing home isn't going to sue the person that doesn't have money. They're going to sue the child that has the money. They don't even have to be the one who got a gift. So just remember that. So, in my opinion, you should not be gifting assets or money away for the holidays. Now, Jeff, aren't there exceptions to that rule? Of course. That's called planning. That's called getting legal advice. That's called talking to a tax professional or a financial professional. And in specific situations, it may make sense. But as a general rule, you should not be doing that. Jeff, I'm 40 years old, healthy as could be, and I have $50 million. Okay, then you can give $20,000 away. Jeff, I'm 85 years old, I'm fair in health, and I have $200,000 in assets. You shouldn't be giving anything away, right? Every single situation is unique and is different. And this is where you need to get legal advice and financial and accounting to determine what is right for your specific situation. But as a general rule, that you should not be giving money away for the holidays. You should not be doing that. Now, the reverse, what should you be giving? Peace of mind, right? Plan your funeral. I can tell you firsthand that when my mom did her pre-planning and when she passed, we knew exactly which casket, the rose gold casket. We knew what song she wanted. We knew exactly what she wanted to have happen because she planned it. I cannot begin to tell you how relieving it was, how comforting it was to know that she picked that out. I cannot fathom what it would have been like to have to pick out the casket in that moment. So give your kids peace of mind. Go talk to the funeral director. Go talk to someone to pre-plan. You can pre-plan it. That doesn't necessarily mean you have to prepay it. And there are some incredible prepaying options that allow you to pay now at today's rates. But most importantly, give your kids peace of mind to know that you picked out what you want. You made those decisions. Pick out your funeral arrangements. Pick out whether you want to be cremated or buried, and where do you want to be buried. And if it's cremation, go ahead and pay for it. Go ahead and make arrangements. Go ahead and take that burden off your family. Make sure you have a power of attorney in place. Make sure that you have something in place so that if you lose capacity, another individual will be able to make those decisions for you, both financially and medically. I know it sounds crazy. I know that you're probably thinking to yourself, sure, Jeff, this is what I'm going to get my kids for the holidays. Yes, you have no idea how comforting it's going to be for them to know that your final arrangements are taken care of and that they know what your wishes are and that you have a document in place so that if they lose capacity, you're able to make decisions for them and you're not going to have to haul them into a court in a guardianship hearing and literally take away their rights to make decisions for themselves. Your children want peace of mind. That's what you should be giving them for the holiday. Look, I'm not even necessarily going to get into the fact that, you want to get a last will and testament so that if they die, their assets go where, you want it to go. Sure, that would be wonderful. And I think your kids would appreciate it if something happened. But ultimately, I really, truly believe that having those decisions already determined as to who's going to make them from a financial and a medical perspective, and so that your final arrangements, your cremation, your burial, that's taken care of, that they don't have to have that burden. That's the first step. Now, how else can you give your kids peace of mind? Well, one of the things that a lot of children are very worried about is being responsible for the nursing home debt of their parent. As I mentioned earlier, there is no question that Pennsylvania has a filial responsibility statute that says that your children are responsible for the nursing home debt of their parent. So what you can give them is peace of mind. Don't be giving money away. Sure, everybody could use a few dollars. But when they realize that they could be responsible because you gave money to a sibling, and the sibling might not have it when they need to have it to pay it back, they would much prefer you didn't give money to anybody. They would much prefer that you stayed solvent and had the money and didn't give it away that could now potentially put them at risk. Jeff, are there ways to do things that will allow me peace of mind for later to know that I can give money away later? Yes, we have a lot of clients that as they start to look at the future, they decide to do a trust. And the trust that we typically are always talking about are trusts for people with less than $12.92 million a person. If you have more than $12.92 million, we have not really done a lot of podcasts on irrevocable tax trusts, non-grantor tax trusts. We really haven't done a lot. Why? Because we don't have a lot of clients who have that kind of wealth. And therefore, it doesn't really make sense in talking about something that applies to very, very few people. The trusts that we are talking about are what are pure grantor trusts, which means it's included in the estate for tax and for estate tax purposes. That is for people who don't have more than 12.92 million. And it allows me to be in control. Remember, a trust is a contract between three parties. The grantor, the person who creates it. The trustee, the person who controls it. The beneficiary, the person who receives it. In these pure grantor trusts, it's included for income and estate tax purposes, and I'm in control. It's in my social security number. It's on my individual tax returns. That's a gift that you can give family, because what they get in return is they get peace of mind that once 5 years goes by, and we are at 5 years and 1 day, the assets that you put into that trust are fully protected. That's peace of mind. That makes them realize that they don't have to worry about being responsible for the nursing home debt of someone else, right? Because they know that you already have all those assets protected. Now, if you want to give money out of that trust once you're beyond the 5-year look-back period, you can, because the money is protected that's in there. So that's actually a strategy that some people will use. They'll put it in the trust, they'll let 5 years go by, and then once 5 years goes by, now they're in a situation where they can gift money out of there and they don't have to worry about that look-back period. Now, that doesn't change some of the other conversations that I had in regards to, you're giving up control once you put it in the children's name. That is true. And it still applies. So that conversation doesn't go away, but at least you're not going to have to worry about the long-term care situation. And presumably, if you're going to do it, you're not going to give money that it's highly appreciated. You're much better off gifting money that is cash or that is not highly appreciated. So we will often talk to people about, okay, if you're going to gift or if you're going to write checks outside of the 5-year look-back period because it's been sitting in the trust, you're not going to give the highly appreciated stuff away. And that also is a great conversation about what a trust is best for. Certainly highly appreciated assets. Why? Because the grantor, the person who creates it, controls the trust, which means that it's included for their estate for inheritance tax purposes, but that means that the children get a step up in basis. So that means that now the fair market value is the date that the children receive the basis in the property. So back to my house example, if it's $200,000, that's the fair market value. And what is 200 minus 200? 0. That's 0 subject to capital gains tax. If you want to learn more about these types of trusts, please check us out at Belomo & Associates at www.belomoassociates.com or 717-845-5390. We offer free educational workshops in the pre-planning contest to discuss the trusts and how they work. This is a niche area that we fill because we're using a specific type of trust in order to provide the long-term care protection in case you need a long-term care situation. We offer these workshops on a weekly basis, and they are free of charge. That will really equip you to be able to understand them and get at what it is that you want to have happen for your family. So as the holidays approach, my advice, do not be giving large checks of money or assets or items to family members. Make sure that you're getting professional help to understand the implications of those decisions and whether or not you are in a position, both financially and health-wise, to be able to do that. But if without specific proper advice and understanding the implications of the fact that there's a 5-year look-back period, of the fact that your children now own the asset and that it's subject to their divorce, their nursing homes, their car accidents. If they die, it's probably going to their family members. Are they going to take care of you? Without you fully understanding all of those intricacies, you should not be giving money away at this holiday season. I don't care that there is a tax rule that says you can give $17,000 away in 2023. That doesn't mean that if you go into a long-term care facility, you will have a problem. I'm telling you, you will. They're going to look back 5 years. They're going to see if any checks were written for more than $500. And if there were, and they were gifts, there's going to be a penalty. There's going to be an issue. So please be very, very careful with doing that this holiday season. Instead, give them peace of mind. Get your funeral arrangements in place. Pick out your casket. Pick out the songs you want to sing. Decide if you want to be cremated or do you want to be buried. make sure you have that financial power of attorney in place to avoid your kid having to go to a guardianship hearing and take away your rights to make decisions for yourselves. Get that trust in place so that they have peace of mind to know that the assets are protected from their long-term care, but also from your divorce, your nursing home, your car accidents. There are so many things that you can do to give your family peace of mind this holiday season. But giving them money or giving them assets is not going to be comforting to anybody. So please do not do that this holiday season. If you would like free educational information in regards to this topic or any other estate planning and elder law topic, please check us out at www.palomoassociates.com or 717-845-5390 and attend one of our free educational workshops. I truly enjoyed the conversation today in regards to holiday planning and what you should and should not get your family this holiday season. I hope that you enjoyed it as well. Please, from every member at Palomo and Associates, every single team member, we wish you and yours a very happy holiday season. To those of you who celebrate, Merry Christmas, Happy Holidays, Happy Hanukkah. I hope everybody is having a wonderful holiday, and whatever they celebrate, we wish you and yours nothing but the best. And here's to a wonderful new year and a great beginning of 2024. Thanks again for attending the Red Wagon Estate Planning and Elder Law Show, hosted by me, yours truly, Jeffrey Palomo, where we discuss all things estate planning and elder law and anything else we want to talk about. And on today's podcast, we talk squarely about estate planning and elder law. Until next time, we'll see you real soon.